Well, hello and welcome to the 2020 Jorde Symposium at Berkeley Law. My name is Sam Lim. My pronouns are he, him, and I'm the editor-in-chief of the California Law Review. For more than 2 decades now, the California Law Review has joined the Brennan Center for Justice and Berkeley Law School in co-hosting the annual Jorde Symposium. And as part of our long-standing partnership, we publish pieces from this annual symposium in one of our print issues. We want to thank our partners for making today's virtual symposium possible. John Cowell and the Brennan Center, Dean CHEMERINSKY and our incredible event services team at Berkeley Law, Professor Tom Jorde, who is the longtime benefactor of this wonderful event and who taught at Berkeley Law for many years, our symposium editor, Casey Reed, and the entire California Law Review team, and of course, our incredible speakers from whom we'll hear today. Finally, I'd like to read California Law Review's land acknowledgement, which we adopted in 2019. And although this land acknowledgement applies to Berkeley, we encourage you to look into the land history of wherever you may be. California Law Review recognizes that Berkeley sits on the territory of Huichin, the ancestral and unceded land of the Chochenyo Ohlone, the successors of the historic and sovereign Verona Band of Alameda County. This land was and continues to be of great importance to the Ohlone people. We recognize that every member of the Berkeley community has and continues to benefit from the use and occupation of this land since the institution's founding in 1868. Consistent with our values of community and diversity, we have a responsibility to acknowledge and make visible the university's relationship to Native peoples. By offering this land acknowledgement, we affirm Indigenous sovereignty and will work to hold the University of California, Berkeley more accountable to the needs of American Indian and Indigenous peoples. In recognition that California Law Review benefits from this history, we pay the Shumi land tax as a small way to contribute to the healing of this history, the sovereignty of Ohlone people, and the preservation of their culture. With that, let me turn things over to our dean at Berkeley Law, ERWIN CHEMERINSKY.
ERWIN, you're muted.
Dean CHEMERINSKY, you are muted.
Sorry, I should know by now. It's my great pleasure to welcome you to the annual Brennan Center Jorde Symposium. I wish we could gather in person, but I'm glad that at least we can do this via Zoom. The Brennan Center Jorde Symposium is an annual event. It was created in 1996 to sponsor scholarly discourse and writing from a variety of perspectives on issues that are central to the legacy of William J. Brennan Jr. The Brennan Center named the symposium in honor of its major benefactor, Thomas M. Jorde, who's a former Brennan clerk and was a longtime professor here at the University of California, Berkeley School of Law. A unique feature of the symposium is that each year the honored lecturer presents the same lecture at 2 different sites, one in the fall and another in the spring, with a different pair of prominent commentators at each site. The fall lecture is typically held here at University of California, Berkeley, where, as I said, Professor Jorde taught for so many years. The spring lecture is at a different school each year. This year, it'll be NYU Law School. The lecture and commentaries are published annually in the California Law Review, as Sam was just discussing. At the outset, I want to thank Tom Jorde for his continued generous support for this symposium. I also want to thank the Brennan Center for its partnership with Berkeley Law over many years in organizing this symposium. My great thanks to John Cowell, who plays such a key role in organizing the symposium each year. And I would be remiss if I didn't also thank our wonderful event staff, Themby Ann Jackson, Jenny Boyden, for putting together this and all of our events. The honored lecturer this year is Professor Pamela Karlan. She's the Kenneth and Harley Montgomery Professor of Public Interest Law at Stanford Law School. Pam is a prolific author, a great teacher, and a renowned Supreme Court litigator. The 2 commentators this year will be 2 terrific election law experts. Professor Nicholas Stephanopoulos, who's a professor of law at Harvard Law School, and Dean Franita Tolson, who's Vice Dean for Academic Affairs and a professor of law at the University of Southern California Gould School of Law. By virtue of this being over the Zoom medium rather than in person, we've changed the format somewhat. Usually there would be a fairly long lecture followed by 2 commentators, but it seems, given Zoom, better to break this up a bit. So the way it's going to work is Pam's going to take about 15 minutes or so to introduce her paper and cover the first parts of it. And then Nick and Franita will have the chance to respond to it. Pam will then present the latter part of her paper. Nick and Franita respond to that. There'll be a discussion among them, and then I'll cut off that discussion at 5:30 and turn to questions and answers. For those who are part of the webinar, if you have questions and answers, please send them in the Q&A function. And for 15 minutes, I'll pose them to the panelists, and then I promise that we'll be done at 5:45. So with that as the roadmap, I'll turn it over to Professor Karlan.
Well, thank you so much, ERWIN, and thanks to everybody for joining me today. I want to thank the people who helped to organize this, obviously our founding father, in a sense, Tom Jorde, and John Call from the Brennan Center. Thanks also, obviously, to ERWIN for hosting me, to Nick and Franita for agreeing to give comments, and to Sam and Casey, whose work is only now just about to begin because they're going to have the job of editing the papers. So the countermajoritarian difficulty was a central preoccupation for 20th century constitutional law scholars. Alexander Bickel, who coined the phrase in the least dangerous branch, located that difficulty institutionally in the courts. Judicial review, he wrote, involved the reality that when the Supreme Court declares unconstitutional a legislative act or the action of an elected executive, it thwarts the will of the representatives of the actual people of the here and now. It exercises control not in behalf of the prevailing majority, but against it. And John Hart Ely, in one of the most influential responses, asserted that representation reinforcing judicial review wouldn't pose that difficulty because it would be carrying out the Constitution's commitment to democratic self-governance, a constitutional development that, in his words, had moved continuously, even relentlessly, away from limits on government by majority. But what if Ely and Bickel were wrong? Bickel, in supposing that the countermajoritarian difficulty was tied to the judiciary, as opposed to being marbled throughout the Constitution, and Ely, in supposing that our constitutional development has moved unidirectionally towards more majoritarian democracy. Observers as diverse as poet Langston Hughes, Professor Alexander Kaczar, and at least apocryphally President George W. Bush have remarked on the cyclical nature of America's commitment to democratic inclusion. Langston Hughes in his poem, Long View Negro, Kaczar in his magisterial history of the right to vote, and Bush in the remark that we are on an irreversible trend toward more freedom and democracy, but that could change. In reality, the way our nation is constituted may be interacting with the way our Constitution was written to produce one of those periods of retrenchment in which we move once again towards government by minority. My lecture and our discussion today is going to explore that interaction. To begin, I want to lay out the constitution of the American electorate. That electorate is changing demographically, becoming less white, more geographically concentrated and homogenous, and more divided, not only in its partisan affiliations, but in its values and its prospects for the future. Then I'll turn to a discussion of ways in which the fundamental hardwired features of our Constitution, in particular the Senate and the Electoral College, are assisting a shrinking white conservative minority to hold on to power. Franita, Nick, and I will then discuss those issues together. And then we'll turn to the courts to ask whether the current Supreme Court is counter-majoritarian in a way that enables this entrenchment. I'll suggest that far from engaging in representation reinforcing judicial review, the court's decisions contribute precisely to the counter-majoritarian force that most concerned Ely, a world in which, in his words, the ins are choking off the channels of political change to ensure that they will stay in and the outs will stay out, and this regardless of what the people will choose. So let me start with the constitution of our electorate. For most of the 20th century and for nearly all our prior history, the American electorate was overwhelmingly white and overwhelmingly native born. Moreover, the mid-century United States was a nation with two parties that overlapped significantly. While there was some regional variation, the two parties were really quite similar in their geographic distribution and actually in their racial and ethnic and even ideological makeup. Just to give you a statistic that most of you will find shocking, 44% of San Francisco County's voters cast their ballots for the Republican candidate in the 1976 presidential election. And overlap between the two parties extended to their attitudes about how to deal with what W.E.B. Du Bois called the problem of the 20th century, namely the color line. Prior to the 1960s, the Democratic Party, for example, consisted uneasily of both a Southern wing committed to the maintenance of white supremacy and a Northern and Midwestern wing whose electoral success often depended on the support of Black voters. The great legislation of the Second Reconstruction, the Civil Rights Act of 1964 and the Voting Rights Act of 1965, was passed by a bipartisan coalition of Republicans and Northern, Midwestern, and Western Democrats. But then things changed. The 1965 Immigration Act ushered in a wave of immigration, with 3/4 of the new arrivals coming from Latin America or Asia, and only 12% from Europe. By 2010, 13% of the United States population was foreign-born, a figure approaching the historic high watermarks of 1890 and 1910. And the foreign-born percentage of the US population will exceed those marks in the next decade. Also, during the next decade, the net growth in the United States' population is going to be primarily a product of immigration rather than new births. Moreover, even the new births reflect demographic change. In 2013, for the first time, a majority of infants born in the United States were non-white. By 2060, only about 1/3 of US children will be non-Hispanic whites. And by 2044, more than half of all Americans are projected to belong to a minority group. America is undergoing a transition that perhaps no rich or stable democracy has ever experienced. Its historically dominant group is on its way to becoming a numerical minority. And the electorate has changed in other dramatic ways as well. Captured by titles of 2 recent books, it's undergone a big sort and a great alignment. The big sort is a description of how Americans are increasingly moving to and living in communities that are homogenous. The great alignment refers to the way in which the range of characteristics individuals possess, from race to religion to the nature of their work to where they live to their ideology, all align. These aspects of individual identity are fusing together and stacking on top of each other. The two parties each identify with one of these competing mega identities. Americans perceive the parties as ideologically further apart than respondents in any other wealthy democracy, and they have reason for that perception. Here's my favorite statistic to illustrate that. In 1960, only 5% of Republicans and 4% of Democrats responded that they would be displeased if their child married a member of the other political party. Today, a staggering half of Republicans and 1/3 of Democrats feel that way. And nowhere are these divisions starker than with regard to race. To give just one salient example involving a current issue, 3/4 of Democratic and Democratic-leaning voters believe that the way the criminal justice system treats racial and ethnic minorities is a very big problem, while only 1/5 of Republican and Republican-leaning voters do. And the current constitution of the electorate maps onto the US landmass in a really distinctive way. The number of landslide counties, counties where either the Democratic or the Republican candidate wins by more than 20 percentage points, has increased dramatically. Even the number of states that are landslides for one side or the other are increasing. The Democratic counties in the United States may be many fewer than the Republican, 500 Democratic counties, 2,500 Republican counties, but the Democratic counties' greater populations and greater productivity mean, for example, that Democratic majority counties were responsible for over 2/3 of the federal income taxes collected in 2014. So there's this stark alignment of urban versus rural and Democratic versus Republican, and each party now views a win for the other party as an existential threat to its sense of national identity or its way of life. Now, there have been long, for probably all of our history, an urban-rural divide, but that divide didn't used to map right onto the partisan divide between large and small population states. That's part of what the Great Alignment is. And what that means is that the growing disjuncture between where Americans live and where hardwired aspects of American political power are located creates a new countermajoritarian difficulty. So let me turn now to the nature of our electoral system and say a little bit about that. Our electoral system consists of a mixture of mutable and hardwired elements. Polling places, for example, regularly change from election to election. Every decade, we have to reconfigure a large number of electoral districts for the House of Representatives, for state legislatures or municipal bodies. But some features of our election system truly are hardwired, that is, written into the Constitution. And by that measure, perhaps the most hardwired provision in our entire Constitution involves the Senate. Article 5, the article that provides the mechanism for amending the document, ends with the proviso that, and here I'm going to quote the Constitution, no state without its consent shall be deprived of its equal suffrage in the Senate. The United States Constitution is already the most difficult to amend of any constitution in the world, but it would require an amendment to Article 5 before it would be possible to amend the requirement that each state be given 2 senators. And one of the things to understand about the Senate that we have now is that while the Constitution may have required an equal suffrage Senate, it doesn't require the Senate we have. The Senate we have is the product of a series of very political decisions about what states to admit and how to create those states. So for example, in the period after the Civil War during Reconstruction, Republicans in Congress pushed through the admission of 4 new states in order to shore up their control of the national government once the southern states came back into the Union. Most strikingly, they denied admission to the more populous but then Democratic Utah, while voting to admit then Republican Nevada, whose population was only 1/7 the size of Utah's. In fact, after the Civil War, the Congress did things like split the Dakota Territory into 2 states. So you might have wondered, why is it that North Dakota and South Dakota get 4 senators and California gets only 2? It's because Congress decided to let in the Dakota Territory and split it up in order to create Republican-leaning states. And this politics of admission are not a relic of the 19th century. Both Puerto Rico and the District of Columbia have larger populations than Wyoming. Puerto Rico actually has a larger population than 20 states. But despite the fact that 78% of DC voters voted in favor of statehood, and despite the fact that there's widespread support for statehood within Puerto Rico, there's no prospect of either of those states being admitted to the Union as long as Republicans control either House of Congress. And of course, the Senate has a countermajoritarian cast. According to the 2010 census, a majority of the US population lives in only 10 states. Those states elect only 20 of the 100 senators, and the mismatch is growing. By 2040, 70% of Americans will live in the 15 largest states. So 70% of the population will elect 30 senators, leaving less than 1/3 of the population to control the selection of the other 70. Now, this would be a problem even if people were randomly distributed among the states. But because of what I talked about before, the big sort and the great alignment, there's a hugely counter-majoritarian cast to this. And I'll just give one example, and then we'll turn to our discussion, which is compare the aggregate vote totals for the 2-party senatorial candidates. In 2018, for example, Democratic candidates for the US Senate received 58% of the Senate votes cast nationwide, while Republican candidates received 38%. Now, this is a landslide adjacent differential in vote totals. For example, in 1984, when he won by a landslide, Ronald Reagan won 58% of the nationwide popular vote, and Walter Mondale won 40.6%. But despite losing the nationwide vote by a large margin, Republicans actually increased their Senate majority. Now, my point here is not that in a nationwide vote for who should control the Senate, Democrats would necessarily receive 58% of the vote. Perhaps in a particular election cycle, they might not even prevail. The current construction of the parties is no doubt inflected by the nature of the Senate, because the Republican Party can gain a Senate majority without having to appeal to the nationwide median voter. The party has less incentive to move towards the center. My point here is simply that the aggregation rules matter, and those aggregation rules translate into governance and policy. When Senator Mitch McConnell argued earlier this year that Republicans should race to fill Justice Ginsburg's seat on the Supreme Court, he said that this should be because Americans reelected our majority in 2016 and expanded it in 2018, ignoring the fact that a majority of Americans did no such thing. As the country becomes more racially and ethnically diverse, less religiously observant, and more economically dependent on the knowledge economy, it retains a Senate disproportionately accountable to white voters who want to turn back the clock. And of course, we've seen twice since 2000 how our current geography creates the risk of a counter-majoritarian president with the concomitant nomination of judges whose positions are also counter-majoritarian. So that's where we find ourselves right now. And I'll stop there so that Franita and Nick and I can talk a little more about this before we turn to the role of the court in exacerbating the problem.
I'm happy to go. Nick, did you want to go first? Or
matters to me. Go ahead, Franita.
Okay. So I really enjoyed the article. It just I found myself alternating between sadness and anger and like, what can we do? And I think my response, at least for the first part of our discussion, is that I want to go a little bit more extreme than you did, Pam, just in terms of the debate. So just to reiterate, you've already pointed this out, so I'll be brief. You're really questioning two things that have driven much of constitutional law for a half a century, right? This idea that the court acts countermajoritarian when it invalidates laws passed through legislatures elected by Democratic majorities, so Bickle's claim. And second, this idea that this type of judicial review is nonetheless okay because it reinforces the Constitution's commitment to democratic self-government. So that's Ely. And so your position is that neither of these arguments really account for our current circumstances in which the countermajoritarian elements of our Constitution, namely the Senate and to some extent the Electoral College as well, the way those have interacted with demographic changes in which geographically concentrated majorities have less power than their rural counterparts. This has combined to produce another period of minority retrenchment that is enabled by the Supreme Court. So that's how I understand the claim. But I'm more interested in why you think that these claims are wrong. And I want to point out that I think they're not only wrong, they're even more wrong than you identify in the paper. So you think Bickle was wrong because the countermajoritarian problem is actually not concentrated in the courts, solely in the courts. It's also concentrated in other features of our government. And it is these features that are being exploited by demographics and partisan sorting. In addition, it may be normatively desirable for courts to push us in the direction of majoritarian democracy through the tool of judicial review. But Ely is still wrong nonetheless, because he assumes that democracy and our move towards it is inevitable, right? This is just a direction that we have been moving in and we will continue to move in. And he doesn't account for the fits and starts that we often experience. So I want to build on this. And I want to point out that the problem of countermajoritarianism is not unique to the courts by taking a bit of a more extreme position. So in my view, countermajoritarianism can never be an argument against judicial review, precisely because American democracy has always been an ongoing project that has never been perfected and is subject to setbacks resulting in lost progress towards a majoritarian ideal. So the assumption that legislation is a product of democratic majorities is not just flawed, because the institutions that enact legislation are structured in a manner that is anti-majoritarian, which is what you effectively show in the paper, but also because the people who elected the representatives do not represent a true majority. This is why, as you point out in the paper, the reapportionment decisions pose no counter-majoritarian difficulty, right? Because the allocation of seats based on decades-old census data meant that the state legislature is structurally counter-majoritarian, and so are its legislative outputs. So you describe those cases as, quote, those allocations reflected something about some group of people and some there and then, which I thought was really clever. But I think it's also true because states also restrict the electorate, right? So this undermines any claim that its system is majoritarian. And they restrict the electorate in all kinds of ways through restrictive voter ID laws, documentary proof of citizenship requirements, voter purges. And as we saw in the COVID era, there were numerous decisions that prevented efforts to make voting easier. So decision out of the Sixth Circuit, which restored Michigan's ban on providing free transportation for people to get to the polls. And that's just one where I'm just like, why? What is the point of that, right? Also, Seventh Circuit decision upholding an Indiana law that permitted those over 65 to vote by mail while denying the same privilege to those under 65 who need an excuse. The 11th Circuit decision, which was probably one of the worst this cycle, made it difficult for those with felony convictions to vote by requiring payment of fines and fees. Supreme Court has also been equally hostile, right? Allowed Alabama to prevent curbside voting, which would help elderly voters and those with disabilities. And in general, making it difficult for federal district courts to loosen ballot receipt deadlines and other things to make voting easier in this pandemic. And I think this really highlights the intersection that you point out in the paper, right? That the anti-majoritarian elements of our Constitution, combined with demographic changes and partisan polarization that cause these elements to favor the sparsely populated rural, solidly red states, but also the attempts to suppress voter turnout and disenfranchise otherwise lawful voters. All of this undermine the argument that legislation represents the democratic will of the people, such that we should be concerned about the countermajoritarian aspects of judicial review. So for me, the answer is, and always has been, that legislation represents the will of some of the people, some of the time. And for this reason, judicial review is imperative because the constituency who make up, quote, we the people, can shrink or expand depending on the prevailing politics. States have a lot of power to define who the majority is, and the needle has moved between substantial disenfranchisement and expansive enfranchisement in fits and starts. One of the lessons of the current election cycle, in which north of 150 million people voted, is that we tend to think that our democracy is working because of raw turnout numbers. But we ignore that while some people have successfully overcome the barriers placed in front of them and cast a ballot, there are others left behind who should be a part of that majority. The controversy over Amendment 4, which I referenced with respect to the 11th Circuit decision, is probably the clearest example of this, in which certain individuals with felony convictions were enfranchised by ballot initiative in Florida, but later disenfranchised by a state statute requiring payment of all fines and fees prior to voting. So this statute was enacted by a heavily gerrymandered Florida legislature to overturn the will of the people, as represented by this ballot initiative that voters overwhelmingly supported. And it really shows the fallacy behind assuming that the legislative pronouncements represent the will of Democratic majorities. The reality is that they often don't. Okay, so I'll stop there.
Great, thanks a lot, Franita, and thank you, Pam, and thanks also to everyone involved in putting together this wonderful event, to the Brennan Center and Berkeley Law School, and of course, Pam for writing this wonderful and provocative article. So I'm glad that I'm speaking after Franita. I think a theme of Franita's remarks was that things are even worse than Pam portrays in her article from the perspective of majoritarianism. I largely agree with both Pam and Franita about how things are, but in these comments, I want to stress a few ways in which things might not be quite as bleak as they appear from both of the sets of comments that we've heard so far. Again, with the clear caveat that I agree with the broad strokes of the presentations of both of the speakers so far. So let me start with the constitution of the American electorate and what this means for American politics. And I'll explain first why I'm a bit more optimistic about American voters in some respects than Pam is. So first, Pam argues that Americans are becoming more polarized by place, with more and more Americans living in very blue or very red areas, and fewer Americans living in competitive places. You know, this is the big sort thesis that's been popularized by Bill Bishop, among others. So according to political scientists who've dug into the big sort thesis, it turns out to be somewhat overstated. And this is primarily because Bishop analyzes counties which vary enormously in population, rather than electoral precincts, which tend to all have roughly the same population. And it's also because Bishop begins his analysis with the baseline of 1976, which was an unusually competitive election all throughout the country. So if one looks at precincts rather than counties, it turns out that competitive precincts are quite common still. And indeed, they're more common than highly uncompetitive precincts just about everywhere in the country. You know, the distribution of competitiveness at the precinct level is still kind of bell curve shaped. It's not a bipolar distribution. And one also finds that the shares of competitive and uncompetitive precincts haven't changed too much over time. So there might be I think there is something to the big sort, but it's not quite as dramatic as Bill Bishop makes it appear. So second point, staying on the topic of geography, Pam invokes the work of Jonathan Rodden and others to argue that Democrats are inherently disadvantaged in districted elections because of their greater geographic concentration. So it's obviously true that Democratic voters are more geographically concentrated than Republican voters. But for districting purposes, that's not the crucial question. The crucial question is whether Democratic margins of victory in dense urban districts are larger or smaller than Republican margins of victory in spread out rural or exurban areas. And the answer to that question is getting closer and closer as rural and exurban areas get more and more Republican. So there now actually are many places in America where Republicans win 75%, 80% of the vote, which is comparable to what Democrats win in quite a few cities. So another way of putting this point is that as the urban-rural divide gets wider in America, this may benefit Democrats in redistricting because more and more, it's not just Democrats who are naturally packed in cities. It's also Republicans who are equally naturally packed in the countryside. Okay, then my third relative note of optimism here has to do with the polarization of American voters. So Pam's great alignment discussion is completely right. American voters are incredibly divided by partisanship. But they're not nearly as divided by ideology or by policy preferences. If you ask the American public their views on lots and lots of policy issues, convert those into left-right ideologies, and then plot the ideological distribution of the American public, again, you get something that kind of looks like a bell curve. And so that tells me that even in a hyper-partisan, bitter political environment, there do actually remain lots of opportunities to find common ground on policy issues to the extent they can avoid getting infected by the partisanship that is so rampant in American politics. Let me note here one area where I'm more pessimistic than Pam about the future of the American electorate. And this has to do with the diversification of America. There's a sense in Pam's article, and I'm not sure if it's ever stated outright, that Democrats may benefit in the medium or long term as the electorate gets more Hispanic over time, thanks to the influx of immigrants. But for me, one of the real lessons of last week's election is that the partisan preferences of Hispanic voters in particular really can't be taken for granted. Last week, Republicans made big gains among Hispanic voters, not just in South Florida with Cuban Americans, but also in the Rio Grande Valley in Texas, in Southern California. Really, if you look at the election returns, anywhere in America that has a large Hispanic population, you saw a surprising swing in a Republican direction. So if this trend holds up, and I have no idea if it will hold up in future elections, then one of the big reasons to believe in an emerging Democratic majority might disappear. If Republicans are able to consistently win more support among Hispanics, who are the biggest minority group in America, that would enable Republicans to remain competitive, not just on the national level, thanks to the Senate and the Electoral College, but everywhere, or almost everywhere, well into the future. Okay, let me quickly turn also to part 2 of Pam's paper, the hardwired institutions at the heart of the American political system, in particular the Senate and the Electoral College. And here too, I want to sound a note of relative optimism, which is one, that it wouldn't take that much reform to make the Senate passably fair. and two, that the partisan bias of the Electoral College is pretty random, and so therefore not as concerning as the Senate. So starting with the Senate, it's not really the case in modern American politics that the Democrats' disadvantage in the Senate is enormous. So I went back and looked at the last 4 presidential elections. Obama won 28 states in 2008 and 26 states in 2012. Hillary won 20 states in 2016, and Biden won 25 states, half the states in this year's election. It's true, of course, the Democrats won all of these states in elections where they earned substantial majorities of the national vote. But nevertheless, I think the election results of the last decade and a half suggest that there's a modest, not an overwhelming structural Republican advantage in the Senate. If we added a couple more states, DC and Puerto Rico, as Pam alluded to, I think that would get us, sufficiently there that we wouldn't worry too much about the Senate as a source of a persistent Republican bias in our system. We're not at a point where Democrats are, 5 states or 10 states away from a fair playing field in the Senate. And then final thing, with respect to the Electoral College, obviously it was biased in a Republican direction in the current election and in 2016, in that the tipping point state across the country with several points to the right of the national popular vote. But this has not uniformly been the case even in quite recent elections. So in 2012, the tipping point state was Colorado, and it was 1.5 points to the left of the national popular vote. And in 2008, the tipping point state was again Colorado, and it was 1.8 points to the left of the national popular vote. So the point is that the bias of the Electoral College, unlike the bias of the Senate, is kind of random. It bounces around based on which states happen to be close in a given year and which candidate happens to win more of those close elections. So, I'll be frank that I strongly dislike the Electoral College for any number of reasons, but I don't think that it has a persistent partisan bias that ought to really trouble us. Many of the other features ought to trouble us, but not this one, in my view. So I'll stop there, and I've got to say what a strange position it is for me to be not the Cassandra, but a note of relative optimism. I'm not accustomed to ever playing that role in panels. So thanks to Pam and Franita for casting me in that unusual role.
Well, I think as we turn to the other part of the paper, this is where your Cassandraism will come to the fore, because of course you are even more cynical, I think, than I about the current role of the Supreme Court. I'll just say a couple of things, which is, I think both sets of comments are super interesting, and I think they're connected in a way that maybe might not be immediately apparent, which is Franita's point. I think the central point that she's making is a point that comes from another Langston Hughes poem in a way, Let America Be America, which is different than Make America Great Again. His point is America never has really fulfilled the promise that the Constitution seems to make, which is that we, the people, will govern. And we are in a time where that tension is much larger than it was during the period in which Alexander Bickel was writing and the period in which John Hart Ely was writing. That is the kind of latter third of the 20th century. We've seen an entire rise of what Dale Ho and Dan Takagi call the new vote denial. Mm-hmm. That is, if you had asked me in 1995, did I think we would be moving into another era of vote suppression, I would have said no. That is, that the Voting Rights Act of 1965 was tremendously successful at enfranchising people. More Black voters in the South were registered by federal examiners in the 2 years after the VRA was enacted than had managed to register in the previous 100 years. By 2008, the rate of voting among African Americans in North Carolina had exceeded the rate of whites. And then what you saw was a series of attempts to cut back on the size of the electorate. That is a cyclical series of events, which are not so much just about Democrats versus Republicans, but are about the desire of a shrinking white minority to hold on to power. And so that question of how that white minority manages to do that is a really interesting one. And this then ties into something, Nick, that you were talking about, which is the change, for example, in this last election in the Latino vote. It is true that Donald Trump increased the share of the Latino vote in those areas, but in South Texas, that meant increasing it from, a small number to a slightly less small number. Or if you look at his success among African-American men, he went from like 7% to 13%. Do I think that means 4 elections from now, 172% of Black men geometrically will be voting for the Republican? No, I don't. But I do think for a variety of complex reasons, the question of whether the two parties will realign in various ways so that the Democratic Party becomes a party of the knowledge economy and people in large cities, and the Republican Party becomes the party of people in rural areas or in border areas, totally possible. That is, the two parties are not fixed in their ideology. The party of Lincoln and the party of Trump both have the name the Republican Party. They bear no relationship to each other. The party of Kamala Harris and the party of Theodore Bilbo are both called the Democratic Party, but they bear no relation to each other. So in that sense, the parties are fluid. But I do think that the Senate, to the extent there is this overlap, is going to be very complicated. And it's going to be especially complicated because you're 100% right on precincts, but precincts are meaningless to people's everyday lives. Nobody talks about the precinct they live in, but they do talk about the county or the like. So let me turn now to the Supreme Court and pick up in a place where Franita kind of left off in the middle of her comments. And that's, she was talking about the Warren Court, which is where I'm going to start. The shorthand definition of the substantive rule that the Supreme Court adopted in the reapportionment revolution cases, and they truly were revolutionary, the most transformative cases in American history, was one person, one vote. But that shouldn't obscure the fact that the reapportionment decisions were quite consciously aimed at a form of counter-majoritarian difficulty that was totally distinct from what Alexander Bickel was concerned about. Because in each of the cases that the court decided, it highlighted the fact that the challenged plan was enabling a numerical minority of the state's current population to control a majority of the seats. And the thing to understand about those minorities is, although the court used some colorful language to talk about them, calling them topsy-turvical or crazy quilts or the like, the population disparities were not random. The apportionments before the court systematically privileged white areas, white rural conservative areas, over areas where Blacks had begun to vote and where the states were more progressive. And the court was well aware of the effects that this bias had on the substantive decision-making about the most pressing issues of the day. Earl Warren was famous for having said, if the Supreme Court had decided Reynolds against Sims, the one person, one vote cases earlier, it wouldn't have had to decide Brown against Board of Education. Nor was malapportionment the only counter-majoritarian difficulty that the Warren and the Berger courts addressed. In addition to the one person, one vote cases, those courts confronted a variety of participation-focused restrictions that were designed to ensure that the ins stayed in and the outs never got any power. One of the court's first forays into this area was Gamillion against Lightfoot, a case that involved Tuskegee, Alabama, a majority Black city that was in the shape of a square. After Alabama enacted a statute that turned the square into a 28-sided figure, all but a handful of the Black residents of Tuskegee had been expelled from the city, but they were still under the city's governance because they lived within 3 miles of the city boundaries. In Carrington against Rash, the Supreme Court confronted a rule that Texas had that said if you were in the military and you came into Texas as a member of the military, you couldn't register to vote there. And Texas was quite frank about the fact it didn't want people with northern attitudes who got stationed in Texas to be able to vote. The Supreme Court said in that case that fencing out from the franchise a sector of the population because of the way they may vote was constitutionally impermissible because it undermined what the court called the maintenance of democratic institutions. Now, the current Supreme Court has completely retreated from that, and probably the best example of that retreat is in the political gerrymandering cases. And Nick was optimistic, but I think now Nick might be a little more pessimistic in a way, because he did so much to try and show the Supreme Court that there were easily judicially manageable standards for saying that fencing people out into districts because of the way they voted violated the Equal Protection Clause. And yet this Supreme Court said it didn't care about that. Indeed, worse than saying that they didn't care about it, the Supreme Court suggested that it's actually legitimate for the government to try and manipulate the electoral rules to the advantage of the people who are in and to prevent change in the elections. So, if you look at the case in which the Supreme Court ultimately decided this, the Rucho case, the Supreme Court had in front of it a state that, for the demographic reasons we've been talking about, had a changing electorate. It was a state that was moving from red to blue. It was a purple state. If you look at the statewide vote in the last presidential election, I think Donald Trump is ahead by about 1.4% in North Carolina. So it's a close state. And yet the Republicans managed, by artful line drawing, to draw congressional districts that were 10 Republican districts and 3 Democratic districts. And when asked on the floor of the legislature, why did you draw a 10-3 plan? The Republican leader said, because I couldn't draw one that was 11-2. So these districts bear no relation to the kinds of districts that the court had upheld in the past. And the court's history was also inconsistent with our history. The idea that district lines can be drawn any way that the politicians want was not something that the framers had assumed. Indeed, the framers of our Constitution assumed that there wouldn't be political parties at all. And the mechanism, therefore, that the framers created for dealing with the unfair allocation of seats in Congress, the grant of power to Congress to override a state's choice, does not work in the current world of political parties. And as for the idea that the framers were deeply concerned with districting, it's worth remembering that for 50 years after the ratification of the Constitution, states didn't elect their representatives through districts. Many of them elected them through general ticket elections, that is, without districting. And the Supreme Court said, well, in those days, a party could have garnered nearly half the votes statewide and wound up without any seats in the congressional delegation. So we shouldn't be worried about unfairness today. Now, it's true enough what the court says, that if you could have gotten close to half the votes and gotten none of the seats. But notice what else is true. In that system, a party that represented a majority of the people could never have lost all of the seats, because the party that received more votes would always win the seats. So the vice of the old system wasn't that it protected minorities, it was that it was too majoritarian. Ironically, although Rucho suggests that the Constitution's given Congress and not the courts the power to do something about partisan gerrymandering, the Roberts Court earlier took a strongly counter-majoritarian position with respect to Congress's most ambitious effort to ensure political fairness. The special pre-clearance, the special pre-clearance regime of the Voting Rights Act of 1965. As I've explained elsewhere, while the one-person, one-vote cases required the court to derive a theory of democracy for itself, the Voting Rights Act was the product of a national majoritarian consensus in favor of a more inclusive electorate. That in Shelby County against Holder, the Supreme Court struck down the formulas used to bring jurisdictions under the pre-clearance regime, thereby relieving the previously covered jurisdictions of the obligation to prove that changes in their election law would have neither a discriminatory purpose nor a discriminatory effect. And it did so in a period of rapid change within the electorate that threatened continued white Republican legislative control in previously covered jurisdictions. Now, what accounts for this counter-majoritarian turn at the court? A number of scholars have offered explanations. Nick himself offers what he calls the legal realist thesis, that the court's decisions empirically benefit the Republican Party, whose presidents appointed a majority of the sitting justices. Whatever the justices' subjective motivations, their decisions align with partisan advantage. Mike Klarman, in his Harvard Law Review forward, which was published earlier this week, adds that in a world of deep ideological and partisan polarization, justices appointed by Republican presidents and by Democratic presidents disagree about values and probably disagree about facts. Thus, for him, whether they're consciously strategizing or it's just motivated reasoning that's doing the work, the bottom line is the same. A Republican court will not protect democracy from Republican efforts to undermine it. And Jack Balkin, as you'd expect if you know his work, offers an even more intricate account in which the current moment falls at a particular intersection of 3 cycles of constitutional time. We're at a point of regime change as the Reagan era is ending. We're experiencing a high level of polarization and confronting what he calls constitutional rot. In such a world, the Supreme Court may be a vanguard of partisan policy, but it's unlikely to be in the vanguard of democracy protection or constitutional renewal. The parties disagree about what democracy is, and as a result, justices on a polarized court promote their appointing party's constitutional values and entrench those values further. Now, for me, regardless of why the court has abandoned majoritarian representation reinforcing judicial review, the starting point for moving towards a democracy more reflective of we the people as we currently exist depends on understanding what has happened. The current court and its democracy depleting decisions are a symptom as much as a cause of our present condition. A difficulty that we face is that while the words of many of the rights creating provisions of the Constitution are capacious enough to respond to changes in the way America is constituted, the words of Article 2, the 12th Amendment, and the equal suffrage provision of Article 5 are not. At some point, the American people are going to have to confront that fact, and they'll have to develop a political and constitutional response. As the great African-American writer James Baldwin long ago told us, not everything that is faced can be changed, but nothing can be changed until it's faced. So back to you, Nick and Franita.
Thanks, Pam. I could lead us off this time, Franita, if that's okay, or doesn't really matter. Sure. So putting on my Cassandra hat for a change, I agree completely with Pam that the current Supreme Court is no friend of democracy, and in fact is often an enemy of democratic values. This court universally declines to intervene when democracy is threatened. For example, when the right to vote is being burdened, or when there's rampant partisan gerrymandering. And this court sometimes chooses to step in when other actors are trying to promote democratic values. And the court steps in ways that thwart those other actors' efforts. This is the story of Shelby County, as Pam explains in her article, and as Franita has also written about. This is the story of campaign finance law, where the court steps in again and again to invalidate restrictions of money in politics. And it may soon become the story of congressional and presidential elections writ large, whenever any actors other than state legislatures try to regulate those elections and thereby violate state legislatures' supposedly plenary power over those elections under Article 1 and Article 2. So the main friendly amendment I want to make to Pam's narrative, and I think this is one that Franita would also agree with, having written a lot about these subjects, is that while we shouldn't expect the court to do anything pro-democratic in the near term, Congress could do a great deal of good. And much of what Congress could do would likely be constitutionally unobjectionable. So here are just some of the policies that Congress could enact that would likely be valid, even in the eyes of this court. Automatic voter registration for federal elections, federally mandated early voting and mail-in voting for federal elections, a strengthened right to vote doctrine that imposes something like strict scrutiny on burdens on the right to vote in federal elections, criteria for congressional redistricting that include banning deliberate or even unintentional partisan skews in district maps, independent commissions for congressional redistricting, generous public financing for congressional candidates, and stricter rules to make sure that nominally independent campaign spending is actually independent campaign spending. And notably, almost all of these policies were part of H.R. 1, the omnibus electoral reform bill that the House passed in 2019. That passage, I think, was a very big deal, even though H.R. 1 didn't become law, because it means that just about every Democrat in Washington is now on record as supporting a really broad, sweeping set of election reforms. So if Democrats somehow get unified control of Washington next year, or if not, when Democrats eventually get control, and who knows when that will be, something like H.R. 1 may well become law. And I think if that happens, the court's anti-democratic turn will matter somewhat less. Congress, in that case, will have stepped in to promote democratic values across a range of areas, and the court's inaction or obstructionism will be less significant. And maybe that's sort of how it should be. Election law academics, including myself, still dream of another Warren court, a court that takes Caroline products seriously, that takes political process theory seriously. But over most of American history, democratic progress happened without the court. The one person, one vote revolution is an exception if you look at the arc of democratic progress over the years. In Reconstruction, it was Congress who was the prime mover, and the court, if anything, obstructed many of Congress's efforts. With the Voting Rights Act, Congress passed the Voting Rights Act. The court initially was Congress's ally in construing the Voting Rights Act, but Congress was the prime mover in passing the VRA. This is also the story of campaign finance reform in the 70s. It's the court, it's Congress who's the prime mover, and it's the court who is the critic and the obstructor of some of Congress's reforms. And so maybe sometime soon, hopefully sooner rather than later, this will be the story of the next landmark congressional electoral reform bill. Maybe we'll again, as we've often had in the past, maybe we'll again have a campaign to improve American democracy that is launched and executed by the elected branches, not by the courts, and it's carried out even as the court, our current court, throws rocks from the sidelines. So that's my friendly amendment, that the court is hopeless and increasingly anti-democratic, but all hope is not lost still, because other actors still can step in and do things to really improve American democracy.
I largely agree with that. I think that I hate that my comments are so dark. I wish I had something light to say. I'll only, sort of second Nick's point about the court being anti-democratic and say, thank God they only take 75 cases a year, right? That kind of limits the damage that they can do. But I will point out that the last part of the paper I thought had just this really rich discussion that really shows how the court has been selective about when countermajoritarian concerns affect the outcome of a particular case. There's like no consistency, no principled approach here that really suggests, that Nick's point about the court just having sort of not being a friend of democracy is the right way to view it. And in fact, I would sort of tie this with my earlier comments and say the fact that there's no real counter-majoritarian difficulty that demands any type of judicial modesty, but instead really a need to respond to counter-majoritarian difficulties elsewhere. This makes the Supreme Court's behavior in recent cases even more inexplicable and indefensible. So the Rucho case, which Pam discusses, the court was very preoccupied with this notion that partisanship in redistricting is legitimate, and that, you know, to the extent that elected bodies overstep, Congress can step in. And so there really is this focus on the constitutional structure as a solution to this, and not the courts, right? That the court should stay its hand, and effectively the court puts the locus of decision in the institutions that are themselves counter-majoritarian in some ways, both in their structure and in how power is exercised. But in contrast, as Pam points out, the court was not shy about invalidating a portion of the Voting Rights Act on federalism grounds, right? So, and this was a statute that was designed to facilitate representation and actually move us closer to the majoritarian democracy that we aspire to be. But I do want to point out that I think that the structural arguments in these cases have become a cover for judicial endorsement of these anti-democratic impulses, right? So it's not really out of a concern about constitutional structure and sort of honoring the structure. And it's clear that this isn't a court that cares about rights writ large. But instead, it really is a way for the court to clothe their arguments in the sort of the language of constitutional structure while behaving in ways that facilitate counter-majoritarian behavior. So in the court's view, it is appropriate to let Congress, with its malapportioned Senate and its heavily gerrymandered House, resolve fundamental issues of democracy and democratic legitimacy. As Nick points out, sometimes this is okay, right? Sometimes Congress can be the body that pushes the democratic ball forward. But the court does not make this distinction, right? Essentially, the court says this in a context in which there's a concern about anti-democratic behavior. So it's not an instance in which democratically elected bodies are acting in democratic ways. Instead, it's about a core problem in democracy that requires judicial intervention. And the court is saying, let the democratically elected branches take care of it, which makes no sense, right? But look at the federalism arguments too, right? Our system of federalism demands that we allow states to disenfranchise otherwise eligible voters absent proof of intentional racial discrimination. It does not matter if many of the state restrictions actually mimic the effects of disenfranchising practices that were common in the darkest periods of American history, right? So the states are essentially replicating many of the effects of laws that disenfranchise substantial portions of the African-American population. But the court takes this position, even though there's nothing that demands it stay its hand, right? There's really no concern about counter-majoritarianism here. But importantly, if we want to continue to give voice to this idea that we're a democracy, right? We say it all the time. We say it even when it's not true. And if we want to continue to hold out our Constitution as this, you know, shining light on the hill, despite its anti-majoritarian features, right? So we kind of accept it for what it is, because in essence, it still permits us to work towards this ideal. So even though our Constitution has anti-majoritarian features, I think many people believe, including myself, that there's still room there for us to evolve into the government and the society who we want to be. Then judicial action can never truly be counter-majoritarian until our institutions and their work products actually reflect the preferences of democratic majorities. And as Nick points out, I think HR 1 is an example of that. Right, that is a bill that facilitates democracy, and one could say does reflect democratic small d preferences, right? So all of these policies importantly fall within the authority of Congress, and it is the type of thing that the court should defer to, but it doesn't have to do it on grounds that are sort of inconsistent with how the Warren Court approached this in the 1960s, right? The court the court doesn't really need a narrative to be deferential to congressional pronouncements that further democracy, right? That is completely consistent with our constitutional tradition. And the court can also tell the difference when you have anti-democratic practices, right? In some ways, I don't want to say the evil of the Roberts Court, but I can't think of any other way to frame it. The evil here is the fact that the court is approaching all of this and selectively using all of this language of counter-majoritarianism in a way that suggests that Actually, Pam, I'm gonna just stop there. I lost my train of thought, but I think my basic point is that the court is really trying to approach this in a way where they are manipulating constitutional arguments about structure and ignoring the constitutional rights that often are at issue here, namely the right to vote, in ways that they don't have to. It doesn't require, this is my point, it doesn't require a new jurisprudence. It doesn't require a new line of cases. It doesn't even require a rebirth of the Warren Court era, right? We can get where we need to get, even if the court decides to be less transformative than the Warren Court was in the 1960s. And I think that's my frustration. So I'll stop there. Pam, you're muted.
Sorry about that. I was coughing before and I didn't want to interrupt you, and I put myself on mute and forgot about it. So I want to throw out a couple of things that I think will enable us to have a discussion among the three of us, and then obviously bring in ERWIN and the audience. One is just to say to the audience that's out there that both Nick and Franita are talking, when they talk about congressional power, they're talking about two sets of congressional powers that might be at issue here. One is the congressional enforcement power under the Reconstruction Amendments, Section 5 of the 14th Amendment, Section 2 of the 15th Amendment, which say that Congress is supposed to enforce the Equal Protection Clause, the Due Process Clause. Congress is actually supposed to enforce the Reduction of Representation Clause, about which Franita has written some really wonderful and provocative scholarship that I think you all should go out and read if you haven't read it yet. And then we're also talking about Article 1, Section 4 of the Constitution, which is the so-called time, place, and manner clause, which says that the states are supposed to set the time, place, and manner for electing their members of Congress, but Congress can, by regulation, essentially override that. And one of the things that's frustrating about the Supreme Court is when it comes to the enforcement powers, how restrictive the Supreme Court has been. Those of you who've taken constitutional law will know about the kind of congruence and proportionality test from Bernie. And the Supreme Court has, has basically treated those amendments, which were enacted in the form they were enacted because the people who fought the Civil War did not trust the Supreme Court to protect minority interests. They trusted Congress to do it. The Supreme Court's treated those as relatively limited, and I'm quite worried that they're going to get even more limited with the current court. Now, Article 1, Section 4's powers purport to be plenary, and the Supreme Court, at least in the Arizona NVRA case, said, Congress's powers to override the state on time, place, and manner are plenary. What worries me about the current Supreme Court is what they will consider to be the time, place, and manner restrictions versus what they will consider to be the qualifications for voting. Because what the Supreme Court did is it dropped this footnote in the case where it said Congress has, sweeping powers for time, place, and manner, dropped this footnote that said, but not for voter qualifications. So for example, Nick is entirely right in talking about HR 1, that, you could have automatic voter registration, early voting and the like. But then the question is, does the court come back in a countermajoritarian way and say, well, the states can put unbelievable voter ID on this stuff? Or does the court come back and say, well, really, when you say people can vote without going to the polls, you're talking about a qualification and not just a manner of voting? Because these words can be quite plastic. And that's a little bit of what worries me, because I'll just say this last thing, and then I'd love to have more of a discussion, which is, on the one hand, you can talk about the burdens that Congress is lifting. On the other hand, they come back with federalism. And you're seeing this most interestingly in some of the shadow docket cases that have gone up this summer about the COVID-related restrictions. And then you can see, Congress arguing in favor of disparate impact standards, and the Supreme Court saying that's too racial. And getting rid of the idea of disparate impact under Section 2. So, I agree 100% with both Nick tonight and Franita more in her previous work than tonight about, Congress should be doing all this. It should be exercising its powers. But the real question is, is Congress willing to get rid of the filibuster? Because if they don't get rid of the filibuster, there's no HR 1. And is the Supreme Court prepared to acquiesce? Or is what you're going to see a couple of decades of real fighting over this before we either move to a more perfect democracy or we find ourselves with a really restricted right to vote. So I'll just toss it open.
So I do have some thoughts about that, in part because I think you're right in your pessimism about Congress, right? Because the court comes in and the court often says, Congress, you cannot do that. And they leave, I like to say, bombs and other opinions suggesting that if Congress tries to do certain things, that the court will come in later to try to restrict it. So that discussion in the Arizona NVRA case, in part, was to kind of warn Congress, like, yes, you have this plenary power, but make sure you stay away from voter qualifications, right?
Yeah, and think about Evanwell too.
Right. So I do think, though, that Congress has to use tools that the court hasn't really weighed in on. Right. Congress has a lot at its disposal that we don't have a lot of case law on, which is why this is primarily why I focused on Section 2 of the 14th Amendment a lot, in part because I didn't feel burdened by case law. Right. Section 2 is one of those provisions where, in for the audience, Section 2 allows Congress to reduce a state's delegation in the House if the state abridges or denies the right to vote. And one of the useful things about Section 2 is that it was designed in part to give Congress a tool outside of the courts. Right. But it still is a part of the 14th Amendment that informs our understanding of what Congress can do under Section 5. And so in some ways, Congress's power is a lot broader than what the court acknowledges. But if the court isn't willing to acknowledge it, it doesn't matter. Right. So one of the things that I've tried to advance in my scholarship is this idea that, maybe Congress can rely on different sources of authority and combine those sources in order to increase its power. Right. Now, the court may or may not go for it. But I do think that the next period that we're entering in a period where we have 6 conservative justices on the Supreme Court. Congress is going to have to be a little bit more creative about how it justifies its restrictions. For example, H.R. 1 cannot predominantly be based on the Elections Clause. It just can't, because it reaches felon disenfranchisement. That is not a time, place, and manner regulation. Right? It has to be based on something else. And Congress just has to be clear and concrete about the fact that it is relying on multiple sources of authority in passing voting and federal election legislation. I think if it does that, it'll be much harder for the court to strike down these pronouncements. And so I think that's why I still have some faith in Congress, even if I have no faith in the court.
Yeah, a few points along those lines. So one is that one additional power that Congress has, which also is barely touched by the case law, is the Republican form of government power. So the Republican Guarantee Clause says that the United States, which is synonymous here with Congress, shall guarantee to every state a Republican form of government. What is a Republican form of government? The courts have never said. More importantly, what the courts have said is that this provision is non-justiciable. And it's non-justiciable in 2 ways. One, a plaintiff can't sue and argue that some state law is a violation of the Republican Guarantee Clause. More relevant here, it also means that if Congress legislates pursuant to the Guarantee Clause, at least in principle, that renders congressional action non-justiciable, beyond the power of the Supreme Court to second guess. This would be a radical step for Congress to say that in our judgment, states that use photo ID laws or states that disenfranchise ex-felons are not providing a Republican form of government to their people. That's a powerful indictment of those states. But if Congress is willing to pay the political price of issuing those kinds of indictments, in principle, then congressional legislation becomes non-justiciable. A second point. Can I
stop you there for just a second, Nick, and raise 2 points that I think are interesting about that. One is, if you take the NFIB against Sebelius case, if you take that case seriously, Congress doesn't even have to say it's using the Guarantee Clause power. All it has to do is pass the law and then let the administration come in and defend the law on the grounds it's the Guarantee Clause. On the other hand, what worries me here is a little bit like the footnote bomb in the Arizona NVRA case, intertribal, which is the court will simply come in and say, well, of course, if Congress were legislating under the Guarantee Clause, we couldn't reach them. But this law that they've passed isn't pursuant to their Guarantee Clause powers, right? I mean, and so I worry about the court's justiciability on that back end being very different than on the front end. I mean, imagine, for example, that Congress passed a law tomorrow. Let's take the broccoli horrible from NFIB. Congress passed a law tomorrow saying, using our guarantee clause powers, we find that a state in which people don't eat broccoli all the time is not really a republic because you got to eat those green vegetables. I mean, obviously, the Supreme Court would say that's not within the guarantee power. So you'd have to figure out how you say to the court, this is so clearly within the guarantee power that it's none of your business.
Yeah, I agree that it wouldn't be helpful if Congress were to come across as basically taunting the Supreme Court by invoking the Republican guarantee clause when there's no plausible Republican guarantee argument. It seems
so
to
you
me
think
in the
they
context,
just have to be kind of in the zone. There's a penumbra to the guarantee clause in that sense.
Not even a penumbra. I think a perfectly reasonable direct application of the clause. And I think one can say with a straight face that it's not a true Republican form of government if you're disenfranchising, 2 or 5% of your citizens, or if you engage in partisan gerrymandering, or if you engage in vote suppression. Those seem to my mind to implicate, the core democratic value of popular sovereignty, which Akhil Amar and others have argued.
They should.
Value
right. I think you're 100% right. They should, but I think in the same way that the court invented the sort of equal dignity of the state's business in Shelby, they'll invent. If they want to get rid of it, they'll invent it, and that's what's so frustrating.
I think
you got to change the court in some ways.
Yeah, I think that it'll be like a Powell versus McCormick problem, right? So the court will come in and say, the age. Residency and citizenship requirements are exclusive. So they have to so Congress has to seat Adam Clayton Powell, but then they can kick him out, right? So the decision of whether to kick him out is non-justiciable, but the court still, weighed in on Congress's power in the first instance. I feel like in a guarantee clause context, the court would do something like, well, Congress's power to determine whether or not a state has a Republican form of government is at the point of admission, right? They'll come in and say that, and maybe it doesn't extend beyond that. It'll be something like that.
Well, that'll be some weird version of originalism, right? Where they'll say the guarantee clause was about the form of government, not about the reality of government. Then they'll put and so it's at the time of admission.
This is actually a conversation they were having in the 1840s with the Dorr Rebellion, right?
Mm-hmm,
so the president was trying to determine whether or not to send troops to Rhode Island, and part of it was this question of whether or not the government was still Republican. It's like, I don't know if that question has been decisively answered about both the political branch's role in sort of policing the boundaries of republicanism as it applies to the guarantee.
Yeah, so one potentially helpful point is that, the argument that the guarantee clause only applies to the point of admission, that was literally the argument of the, Confederate Southerners before the Civil War, which maybe would counsel the current court against embracing that argument. Maybe. I'm not sure. At the same time, I think it's also been decisively rejected for, it's never been an argument that's prevailed. It was, it's John C. Calhoun's argument. It's never been a winning argument in American history.
But I don't know if it's a losing one, since we had almost a century of, substantial disenfranchisement in the South until the 1960s, right? I mean, clearly states that were unrepublican went unrepublican for almost a century.
But that's consistent with it being non-justiciable, that courts won't intervene to redeem republicanism in states that have lost.
So this is where the one case that actually discusses the guarantee clause and Black disenfranchisement at all kind of plays a neat role. It's this case from the DC Circuit in 1964, where they say, yeah, we should decide this case, but it looks like Congress is about to pass a Voting Rights Act, which sort of suggests, that kind of reinforces your point, Nick, which is really the guarantee clause is a source of tremendous congressional power. It's just a source they've never used. And then the question is, does their failure to use it for 150 years since the Civil War mean that it's kind of fallen into desuetude? Or is it still part, is it still really part of the Constitution and we should revive it?
It's not never, of course, right? The Reconstruction Acts themselves were passed in part pursuant to the Guarantee Clause.
Yeah, that's why I said it's fallen into desuetude, because it hasn't been used in 150 years, right? Because that was the last time we saw Congress use it, and they haven't used it since.
It's a sleeping giant, right? It only awakens once every 150 years.
It's like this cicadas.
I would, and Nick, you can, clarify this if I'm wrong, but I would say that any time that Congress admits a state, they have to do an analysis as to whether or not it's Republican, right? So I would say it hasn't been used since 1950, which makes me feel a lot better.
1959, yeah.
1959, right, with Hawaii.
Yeah, and Alaska, yeah.
Is your point, Franita, that anytime Congress admits a state, it necessarily has to make a judgment that the state complies with Republican principles?
Exactly, yeah.
No, that's a really good point. It's not as dead as it looks.
Right.
It's actually even less dead than that. I forget the article where I read about this. Actually, I think it's by Ethan Lieb, like one of his early articles. He notes that kind of some random congressional statutes that seem to have nothing to do with elections or democracy have actually cited the Republican Guarantee Clause. And I forget his exact examples, but like gun control legislation in the 1960s, I think it was one example. And there's some other kind of equally surprising cases where actual federal statutes refer to the Guarantee Clause. So it could be just that these uses haven't been noticed because these bills weren't challenged in plausible litigation. But I think if one went through and just did a control F in the statutes at large, one would find some unexpected references to the Guarantee Clause.
So here's a question for both of you, which is, what do you make of like all of the recent rhetorical moves by the Republicans to say this country is not a democracy, it's a republic? Do you think that they're doing a version of this that sort of seizes the idea of Republican form of government and says a Republican form of government can be counter-majoritarian in a deep, even in its political branches, in a deep way?
I think that point highlights the fact that we are a country of democratic norms and not really a democracy, and norms can be eroded, right? But I also view the Republican guarantee as a floor that can be exceeded and not a ceiling, right? And so I think they're viewing it as a ceiling, right? So
interesting.
Yeah, I think they're saying like, as long as we're a republic, nothing else is required of government. But for me, because we're a country of democratic norms, government has obligations that flow from that.
Yeah, I've never quite understood what is supposed to flow from the distinction between a republic and a democracy. Like a republic is not an aristocracy, a republic is not a monarchy, a republic is not a dictatorship.
But it can be consistent with those things. That's the problem.
Do you think so? You think a republic can be consistent with authoritarianism?
If you read some of the early Enlightenment scholars, right, they were talking about republicanism as a check on the monarchy. Right, the fact that republicanism also manifested in ways beyond sort of political power. So it's not just about voting; it's also about civic virtue and values, and all of these different things flow into this meaning of republicanism. So there were questions about what Republican government in the context of less democratic forms of government, and that's part of the problem. And that's why they keep saying we're a republic and not a democracy, because they don't want broad participation. And technically, you can have a republic without it. It's about.
That seems to be the key, right? Which is a republic does not require total popular enfranchisement in the way that a democracy does. It simply requires that the people who are allowed to participate in a civic regarding way. Yeah.
I think we all agree the republic permits mass democracy, even if it doesn't require mass democracy.
I think that's right.
Or you think a republic excludes mass democracy?
No. I think you can have a democracy in a republican system.
Erwin, are you going to jump in? All I see is a little red microphone and a name.
Yes, I am here. I was letting your discussion go, and I've got questions from the audience if you're ready for them.
Sure.
First question was, and it describes what we've observed recently, and then says, is there room for more national regulation and standardization of elections, such as with regard to registration and absentee ballots?
So I think the answer is yeah, there's room for it. And I think Nick was alluding to this when he was talking about congressional authority. So Congress could clearly do that for the elections for the US Senate and the US House using Article 1, Section 4 and its time, place, and manner restrictions. So in the same way that it's Congress that says we vote on the first Tuesday after the first Monday in November, that's a statute that's been around since I think the 1830s or 1840s. Congress could say, you know, here's a standardized ballot that you use for those elections. And one of the things we discovered with the motor voter law, the NVRA, is if you require this stuff for congressional elections and Senate elections, it often pulls a lot of the other elections along with it because it's too costly for the state to run two systems. If they've got to comply with the federal system for one, they'll comply with it for both. So yes, the problem I worry about, because of the way, for example, HAVA was passed after the 2000 debacle, is that you end up with like a push me pull you statute in which in return for getting a couple of good things, you get a bunch of bad things as well. And that's kind of what worries me.
I had a related question for both Pam and Franita that connects to this. So on the issue of voter qualifications, which Pam raised before, do you two think that Oregon v. Mitchell is good law anymore? You know, once upon a time, Congress directly regulated qualifications for voting in congressional and presidential elections, and the court upheld that congressional statute. So do you think Oregon has been implicitly overruled by the current court?
I think so.
There's a footnote that I'm trying to remember where the court kind of suggests they're not sure what Oregon against Mitchell actually means.
Scalia didn't treat it as controlling. He said that there was no opinion. Yeah, he said that there was no opinion, no controlling opinion that came out of Oregon versus Mitchell.
I mean, there was a concurrence that was the narrowest possible basis for decision, which is supposed to be controlling. Right. You had four justices taking a broader view, and you had, I think it was Justice Black, right, who wrote the controlling opinion. Yeah, it certainly seems like under Marx, this is supposed to be valid precedent.
I've always read Arizona Intertribal to silently overrule that case.
What do you think, Erwin?
I think that the court today wouldn't follow Oregon versus Mitchell. That, you know, you could certainly say, well, what should be treated as the majority opinion of the United States versus Marx? But I think for this court, there wouldn't be any. I would find it very hard to reconcile it with what the court did in Shelby County.
Yeah.
We've got some more questions too. Let me figure out how to get them. I'm of the opinion that the Senate should be I'm reading that the Senate should be abolished, but clearly that is a pipe dream. Might a compromise be reached by addressing the red nightmare of urban areas lording it over the surrounding rural areas that grow their food and host their highways, etc.? That is, the nation as a whole has at least some interest in spreading power geographically, and this could then be something that brings everyone to the table.
So I'm not sure exactly what the suggestion is there, whether the suggestion is sort of like, you know, maybe Michael Bloomberg and a couple of other people should just pay a lot of people to move to North Dakota and then take over their seats in the Senate. You know, there was this student note, I don't know how many of you have seen it, in the Harvard Law Review last year called Pack the Union, that suggested if the Democrats took over Congress, they should just create like 178 new states all in the District of Columbia, admit those states to the Union, then amend the Constitution to change all the stuff in the Constitution that's anti-democratic, and then dissolve those states, I guess.
Clever.
Let me ask the next question.
Who's bold?
I'm reading again. This is quite a depressing picture of an attempt to entrench white minority rule in spite of demographic changes. My question, is there a level of voter suppression and or countermajoritarianism established in the three branches so that if reached, we can no longer defensively call the political system democracy? For example, before the Voting Rights Act in Reynolds, I think it's difficult to say that America was a democracy since Black voters didn't have a voice. In the future, as Professor Karlan predicts, if demographic changes mean New York City votes only a small fraction of the power of a Utah vote, when is it no longer a democracy?
now?
So, I mean, I think a lot of this is the last ditch attempt to forestall demographic change, and that in the long run, and this is not the George Bush, in the long run, we're on an irreversible course towards more freedom and democracy, but that could change. But in a slightly longer run, I think we will see the cycle shift again. That is, we'll go back to a more participatory democracy in the same way that, you know, at the end of at the height of the first Reconstruction, the level of turnout among Black men over the age of 21, which was the only part of the Black electorate that could vote, was like 80%, right? And you were talking about, you know, relatively poor and largely illiterate folks voting in huge numbers. And we might see, you know, we might see that again at some point. I don't mean that they will be poor and illiterate. I mean that we will get back to a level of turnout like that, but it's going to take a while, and it's going to take a political movement. I mean, the most interesting thing to me about this most recent election is Stacey Abrams in Georgia.
Can I ask a question, Pam? Because I would love to get your thoughts about that question as related to Jack Balkin's constitutional right theory.
Yeah.
So one of the things that he talks about is this fact that, you know, we're seeing all of these efforts to, you know, shrink the electorate, and, you know, this is all part of like the efforts to entrench a political minority, and we're at a moment of regime change. And part of it, he describes that as constitutional right. And I just wonder, you know, given the question about when have we reached a point where we can no longer call ourselves a democracy, is it fair to say that maybe we are always in a moment of constitutional right? You know, not necessarily the regime change point, but the fact that we're always fighting against our worst impulses that could push us further and further away from being a democracy. I just wonder if right is our baseline, in part because we always seem to be in a moment where we're fighting against efforts to disenfranchise. I don't know if we've ever gotten away from that.
Well, there have been moments where the public commitment has been moving in the opposite direction, right? I mean, I think the height of the second Reconstruction, yes, there was tremendous resistance, but there was also tremendous public commitment to the idea that everyone should have the right to vote. So it's not that we're always, you know, it's not like some version of from hour to hour we ripe and ripe, from hour to hour we rot and rot.
Yeah.
There are some moments that are more rotten than others, and there's some moments that are more fecund than others.
It sort of seems to me like there were 30 decent years, you know, after the Voting Rights Act, maybe the 70s, 80s, and 90s, when, you know, absolutely there was racial vote dilution, especially at the sub-state level around the country. Some states kept doing some degree of voter suppression, but it was nothing like what we're seeing in the last 10 or 15 years in terms of systematic voter suppression, unbelievably extreme partisan gerrymandering. You know, I look back at that 30-year period, like 1970 to 2000, as being quite a bit more benign than the 10 or 20 years since then.
Yeah, I don't know if I'm just overly. I was just going to say, I don't know if I'm just overly pessimistic, in part because the time period from South Carolina versus Kassenbach to City of Mobile was literally 15 years. You know, it's just the court did an about face just so quickly after being an ally of Congress.
Yeah, although they remained an ally of Congress in the sense that the Jingles test in 1986, so the period between 1986 and 1986 to 1993, when they come in with Shaw, is a period of unbelievable growth. I mean, if you look at that was the period in which I was a full-time voting rights litigator. And it was like every day you'd come into the office and think, what envelope do I want to push today? Because it was really hard to lose. I mean, we did judicial elections. We did defendant class actions with 200 jurisdictions in them, you know, and then the court turned. And I think the thing that creates some level of pessimism is, did the court turn because the country turned, and did the country turn because they were finally moving away from a white supremacist political system?
Yeah.
You know, it's like, why are people voting for Donald Trump? Is it mostly economics? some people say yes, but then obviously like Alan Abramowitz and people like that say, no, it's about racial resentment. It's not about economic resentment. It's about racial resentment. And the economic resentment is one of those things that for me at least creates a sense of optimism. If it's about economics, economics is, we can fix pretty easily if we just have the commitment to a more redistributive system, a fairer system of taxation, better government spending. Whereas if it's about race, that's a lot harder to fix.
Mm-hmm.
Doesn't the question in Franita's comment a moment ago assume that there is a binary definition? It is or it isn't democracy. And doesn't your set of comments really reflect it's not that at all? And it may be much less that we have a definition and a test for democracy that we're measuring the country against, in more the rhetorical force of the word democracy.
Right.
Twice in the last 20 years, the Electoral College has let the president be somebody who lost the popular vote. Pam, you presented all of the statistics with regard to how unrepresented the Senate is. You've talked about partisan gerrymandering. In light of all of that, if we had a test for democracy, wouldn't we fail it?
Well, we certainly wouldn't be getting high honors.
And there are comparative efforts to score different countries in terms of their performance on different democratic indicia. And they show the U.S. as having fallen. We're now considered something like a flawed democracy, or I forget the exact term. We're no longer in their top category. But I think this gets to Erwin's point, that democracy isn't binary, that it's absolutely a very long continuum. And I do think we've clearly slipped a bit since 10 or 15 years ago. Most other Western countries, I think, are clearly better than we are, in the sense that there aren't efforts at rampant voter suppression. There isn't gerrymandering. There is a national popular vote for the executive, so there's no possibility of wrong winner outcomes. My wife is Australian, and just about every pathology in the American electoral system doesn't exist in the Australian electoral system. Part of why she's in America is there's nothing to do really if you're an election lawyer who lives in Australia. So I do think we're still a democracy, just we're not as strong a democracy as we could and should be.
Let me ask another question from the audience. Again, I'm reading. How can we rely on a counter-majoritarian system of governance to expand democracy in a way that threatens its own power? In other words, if the Democratic Party cannot overcome the gerrymandering and other counter-majoritarian obstacles, how can they ever pass legislation to remove them?
They can overcome those obstacles sometimes. The typical election won't be enough, but we're lucky enough not to live in a period like redemption, where the barriers were insurmountable. The barriers now are ones that a sufficient majority can overcome. In recent memory, Democrats had a filibuster-proof majority in the Senate. In recent memory, Democrats controlled the whole federal government. So, yes, Democrats have to win by a substantial number of points to get this much authority, but that's conceivable. These barriers aren't ones that are impossible to overcome.
I will point out that I think the barriers are one of the reasons why I'm dubious about the democracy label, right? We have 50 different states, all have varying forms of government that can be democratic or less democratic. So yeah, maybe we're a flawed democracy, but I think so much of that rides on this fact that people overcome barriers, and we don't focus enough on the fact that there are barriers. And maybe that should affect whether or not we can call ourselves a democracy.
I'll read the next question. Where will the originalists look to define a republic as referenced in the guarantee a Republican form of government to the states? What sources will they use is the question.
I'm pretty sure they won't start with Plato's Republic, or at least I'm hopeful that they don't start with Plato's Republic, which was, of course, totally consistent with slavery and the subordination of women and everything. I mean, I assume they will start looking at a bunch of 18th century political philosophy treatises. But that's my best guess as to where they'll start.
So does that mean I have to take my discussion of Plato's Republic out of my book, Pam?
No. No, because you're not claiming to be an originalist.
No, I'm not.
Yeah.
But this all assumes that originalists are actually implementing the provision or evaluating some congressional law for compliance with the provision, right? We only get to the question of what a republic means if the court reverses itself on the justiciability of the guarantee clause. So I would hope that we never get there because the 2 centuries of precedent that we have about the guarantee clause being non-justiciable remain in effect. And so Congress gets to pick what a republic is, and the court doesn't get to, interpose its own judgment about what republic means.
So you do a version, Nick, you do a version there of a hyper-aggressive twist on Justice Kavanaugh's embrace of the independent state legislative doctrine in the Pennsylvania case. You'd say everything turns on the word Congress, not on the word Republican form of government. Is that Congress shall guarantee. And so all we should really ask is, well, who's Congress? And we turn around to the court and say, whatever Congress is, it's not you.
Yeah, although it's not really a textualist point because the text says the United States shall guarantee, not right. Congress shall guarantee. So that could be, I suppose, any of the 3 branches that are doing the guaranteeing. Everything hinges on this really being completely non-justiciable. And so entirely at the discretion of Congress and not at all at the discretion of the court.
I suspect whether it remains non-justiciable will depend on how the power is being exercised.
Yeah, I mean, suppose Congress just passed a law that said every state has to make the state university tuition free because we can't have a republic in which people don't have equal access to education, and higher education has become critical, and therefore we find a state that charges like huge amounts to students to attend its state universities is not really a republic. I mean, you think the court would say, well, that's not really justiciable because it's up to Congress to decide what really a republic means?
No, I share that concern that if Congress aggressively pushes this power, that might induce the court to reverse its precedent on justiciability. I've had a couple of conversations with people in the House on this. They seem willing to invoke this power if they have the chance to.
Yeah.
But I think you're right that this court would not look kindly at efforts to completely cut it out of the act of judicial review, which is what this is really an effort to do.
Yeah, I mean, what would worry me is they would say, well, yeah, Congress has the authority to decide what a republic is, but the states were given the authority to decide what the qualifications of voters are in Article 1. And the way to reconcile this is to say the state decides who can vote. And then Congress is really talking about how you allocate power within the electorate.
We're in our last minutes, but I want to go to one question that came in. And again, I'll read it because it really bears on this discussion of the guarantee clause. The person writes, to go back to the earlier discussion of the guarantee clause, the Supreme Court in Minor versus Happersett said that the states at the time the Constitution was ratified, quote, were accepted precisely as they were, and so said, quote, thus we have unmistakable evidence it was Republican in form when the meaning of that term is employed in the Constitution. That was in 1875. Given the current originalist trend on the Supreme Court, do you think the court is likely to return to the view expressed in Minor that any system of suffrage that had at the founding is by definition Republican? So any attempt by Congress to require anything more can't be justified under the guarantee clause? Or do you think there's any hope for a more, to use his favorite word, living conception of the clause?
I really would love to see them tackle the slavery issue if they go down that route. Because it seems to me that it's hard for a court now to sort of adhere to this view that what was Republican in 1789, given the slavery issue.
I mean, the hard thing what the court would say, and I wouldn't be any more persuaded by this than you are, Franita, but what they would say is, well, but the 13th Amendment changes the definition in the same way that Minor against Happersett's, for those folks in the audience who haven't read it, Minor against Happersett was about whether women should have the right to vote under the Privileges and Immunities Clause. And of course, today we would all say that a state would not have a Republican form of government in some sense if they disenfranchise women, because the 19th Amendment says you can't do that. And so what I worry about is they come back and say, which I don't find persuasive, but they come back and say, well, amend the Constitution if you want to add anything to what the restrictions were in 1789. And what worries me about this court, because you saw it in the 11th Circuit in the en banc that Franita started us off by talking about in the Amendment 4 cases, they'll find things like forcing people to pay a whole bunch of fines and fees
Right.
is perfectly consistent with having a Republican form of government, because people who were too poor to pay were not enfranchised in the 1780s, and the poll tax amendment only deals with poll taxes.
It's so interesting though, because there seems to be this tension between, so I think you're right? They would just point to later amendments to say this is what republicanism means now in light of how the Constitution has been amended. But even at the founding, the concept of republicanism wasn't a set thing, right? The framers just really thought it was something that defied explanation, right? Everybody kind of knew what republicanism involved. And so as a court, how do you enforce that? Right? How do you enforce that based on originalist ideals when the founding generation weren't in agreement about what republicanism required?
It's just like
I'm
obscenity.
gonna interject
when you see it.
There's so much more to say, and I apologize to those whose questions we didn't get to, but we have gotten to 5:45, and it's been a long time for people on Zoom. So with that, I want to thank Pam Karlan for her terrific paper. Pam, there have been many requests that we received for seeing copies of the paper. I think the answer is it'll be in the California Law Review hopefully soon.
Well, it won't be in for a long time, but I'll also be posting drafts.
Okay, so people can get it on Pam's page at Stanford Law School. Thanks to Nick Stephanopoulos and Franita Tolson for their wonderful commentary. Again, my thanks to Tom Jorde and to the Brennan Center and John Cowell for helping put all this together, for their sponsorship, for their unflagging support for this wonderful program. And thanks to all of you for tuning in tonight. Wish we could all be together, but it's great that we were able to do this.